If you or someone you know is waiting for an immigrant visa from outside the United States, you need to stop everything and hear this right now. The Trump administration has just announced an indefinite halt on immigrant visa processing for nationals of 75 countries, further restricting legal pathways to the United States and expanding earlier travel and visa limitations. This is not a minor policy adjustment. This is a massive development that could affect millions of families, workers, and employers across the globe. And if you are from one of the affected countries, the decisions you make in the coming days and weeks could determine your entire immigration future. Welcome to U.S. Policy Brief, your reliable source for the latest news on U.S. immigration, visas, green cards, and citizenship. I am your host, Daniel Brooks. Today we are covering one of the most significant immigration announcements of 2025, and I want to make sure you understand every single aspect of what is happening, who is affected, and most importantly, what you can do to protect yourself and your family. Before we dive deep into this topic, make sure you subscribe to U.S. Policy Brief and hit that notification bell. Immigration policy is changing rapidly, and missing even one update could cost you your opportunity to come to America or reunite with your loved ones. Now let us get into the details of this breaking news. According to U.S. officials, the suspension becomes effective January 21st and applies only to immigrant visas, including employment-based and family-based visas. Non-immigrant visas, such as tourist, student, and business visas, are not included in the halt. The impacted countries include Brazil, Colombia, Egypt, Haiti, Somalia, Russia, Nigeria, Cuba, Iran, and Iraq, among many others. In total, 75 countries are affected by this processing pause, and the list includes nations from every continent. Let me be very clear about what this means. If you are a citizen of one of these 75 countries and you have been waiting for your immigrant visa to be processed at a U.S. embassy or consulate abroad, your case is now on hold indefinitely. There is no timeline for when processing will resume. There is no guarantee that it will resume at all in its current form. And there is no exception process that has been announced for hardship cases. Now let me explain what the government is stating about this decision and why they claim it is necessary. The halt is part of the administration's effort to expand enforcement of the long-standing public charge rule, which permits immigration officers to refuse entry to people considered likely to depend on public benefits. This rule has existed in various forms for over a century, but its application and interpretation have changed dramatically depending on which administration is in power. Tommy Pygott, a spokesperson for the U.S. Department of State, stated in a statement Wednesday that the State Department will utilize its long-standing authority to deem ineligible potential immigrants who would become a public charge on the United States and exploit the generosity of the American people. This language is significant because it frames the pause as a protective measure for American taxpayers rather than as a restriction on immigration. Pygott added that immigrant visa processing from the impacted countries will be suspended while the department reevaluates its screening procedures to prevent the entry of foreign nationals who would receive welfare and public benefits. In a separate social media post, the State Department indicated the freeze would remain in effect until it finishes a review of its immigrant visa screening procedures. This open-ended timeline is what makes this announcement so concerning for millions of applicants who have been waiting years, and in some cases decades, for their visas. To understand the full impact of this announcement, we need to examine what the public charge rule actually is and how it has been applied historically. The concept of public charge dates back to the Immigration Act of 1882, which allowed immigration officials to deny entry to anyone likely to become dependent on the government for support. For most of American history, this rule was applied narrowly, typically only to people who were completely unable to support themselves due to severe disabilities or extreme poverty. However, in recent years, the definition of public charge has become a battleground in the larger debate over immigration policy. During the first Trump administration, there was a significant effort to expand the definition to include anyone who might use almost any form of public benefit, including non-cash benefits like food assistance and housing vouchers. That effort faced numerous legal challenges and was ultimately reversed by the Biden administration. Now, with the return of the Trump administration, we are seeing a renewed push to expand the public charge definition even further. The November proposal by the Department of Homeland Security and U.S. Citizenship and Immigration Services would direct immigration officers to consider whether an applicant is likely to utilize benefits such as Medicaid, Supplemental Nutrition Assistance Program, Children's Health Insurance Program, and non-cash benefits including free or reduced-cost school lunch programs. This is a dramatic expansion from traditional interpretations of the rule. Under this proposed standard, even middle-class families who might qualify for certain benefits based on income thresholds could be deemed likely public charges and denied visas. The proposal also reduces the standard of proof officers must meet when making these determinations, making it easier to deny applications based on speculation about future benefit use rather than concrete evidence. While this expanded rule has not yet become effective, it is anticipated later this year and is likely to encounter legal challenges from immigration advocacy groups. However, the current processing pause appears to be the administration's way of implementing the spirit of this expanded rule even before it becomes official policy. Now let me break down exactly what this halt does and does not cover, because there is significant confusion about this. The suspension applies only to immigrant visas processed abroad, meaning it primarily impacts people seeking to enter the U.S. permanently from overseas. Immigrant visas include family-based categories, such as immediate relatives of U.S. citizens, family preference categories, and the diversity visa lottery. They also include employment-based categories ranging from EB-1 for priority workers to EB-5 for investors. The halt does not apply to non-immigrant visas. This means tourist visas, also known as B1 and B2 visas, are not affected. Student visas, including F1 and M1 visas, are not affected. Business visas and temporary work visas such as H-1B, L-1, and O-1 visas are not affected. Short-term travel for major events, including the 2026 World Cup, will still be permitted according to State Department officials. However, and this is critically important, individuals from affected countries may still encounter delays or denials if they are subject to separate travel bans or national security restrictions already in effect. The immigration landscape has become incredibly complex, with multiple overlapping restrictions that can affect the same applicant in different ways. Let me explain how this fits into the broader pattern of policy changes we have been seeing. Many of the countries included in the new processing halt were already subject to expanded travel bans announced late last year. Those earlier measures suspended asylum cases, green card processing, and citizenship ceremonies for nationals of certain countries deemed security risks by the administration. This new announcement essentially adds another layer of restriction on top of existing limitations. Since returning to office, President Donald Trump has moved aggressively to restrict both legal and illegal immigration. The State Department, now led by Secretary of State Marco Rubio, has been playing a central role in implementing new limitations. We have seen increased visa denials across multiple categories, longer processing times, more requests for additional documentation, and now this unprecedented pause affecting 75 countries. What makes this pause particularly significant is that it targets legal immigration pathways. These are people who have been following the rules, waiting in line, paying fees, submitting documentation, and doing everything the United States government has asked of them. Some have been waiting for over a decade due to backlogs in certain visa categories, and now, with no warning and no timeline for resolution, their cases have been frozen. Let me discuss the specific impact on different types of visa applicants. For family-based immigrant visa applicants, this pause is devastating. Imagine you are a U.S. citizen who filed a petition to bring your spouse, parent, or sibling to the United States. You have gone through the entire I-130 petition process, received approval, submitted documentation to the National Visa Center, paid your fees, and your family member was waiting for their interview at the U.S. Embassy. Now that interview is indefinitely postponed. For families who have already been separated for years due to processing backlogs, this is an emotional blow that is difficult to describe. Parents who wanted to see their children get married, grandparents who wanted to meet their grandchildren, siblings who have not seen each other in decades. All of these reunions are now on hold, with no end date in sight. For employment-based immigrant visa applicants, the situation is equally challenging but in different ways. Many professionals from affected countries have been offered jobs by U.S. companies that were contingent on obtaining an immigrant visa. These individuals may have already resigned from their current positions, made plans to relocate, and enrolled their children in American schools. Now, they are in limbo, unsure whether to continue waiting or to make alternative plans. U.S. employers are also affected. Companies that have invested significant time and money in sponsoring foreign workers for green cards now face the prospect of losing those employees to competitors in other countries. The global market for skilled talent is highly competitive, and other nations like Canada, the United Kingdom, and Australia are actively recruiting the same professionals that American companies want to hire. For diversity visa lottery winners, this pause is particularly cruel. The Diversity Visa Program allocates 55,000 visas each year to nationals of countries with historically low rates of immigration to the United States. Winners are selected randomly from millions of applicants, and for many, winning the lottery represents a once-in-a-lifetime opportunity. But diversity visas expire at the end of each fiscal year. If processing does not resume in time, lottery winners from affected countries could lose their opportunity forever through no fault of their own. Now, let me discuss what this means for you depending on your specific situation. If you are outside the U.S. and applying for an immigrant visa from one of the impacted countries, you should expect immediate suspension or indefinite delays in visa processing starting January 21st. Your embassy or consulate interview, if it was scheduled, has likely been canceled or postponed. You will not receive your visa until the pause is lifted and your case is rescheduled. What should you do in this situation? First, monitor embassy and consulate communications closely for country-specific guidance. Different embassies may handle this pause differently, and there may be exceptions or updates that apply to your specific case. Check the embassy website regularly, and make sure your contact information is current so you receive any notifications. Second, do not make any irreversible decisions based on the assumption that your visa will be issued soon. If you are planning to quit your job, sell your home, or make other major life changes in anticipation of moving to the United States, you should reconsider those plans until there is more clarity about when processing will resume. Third, consider speaking with an immigration attorney before making travel, job, or relocation decisions. An experienced attorney can help you understand your options, including whether there are alternative visa categories that might be available to you or whether you might qualify for any exceptions. Fourth, document everything. Keep copies of all communications with the embassy, all receipts for fees you have paid, and all evidence of hardship caused by the delay. This documentation could be important if there are future legal challenges to the pause or if the government creates an exception process for hardship cases. If you are already in the U.S., the situation is different but still requires careful attention. The halt does not directly impact adjustment of status applications submitted domestically. If you are already in the United States on a valid visa and you have filed Form I-485 to adjust your status to permanent resident, your case continues to be processed by USCIS, not by a consulate abroad. However, heightened scrutiny under public charge rules may still apply to your case. You should avoid unnecessary international travel if you are from an impacted country and your case is pending. Here is why this is critically important. If you leave the United States while your adjustment of status application is pending, you may need to obtain an immigrant visa at a consulate abroad to return, and if that consulate is subject to the processing pause, you could be stranded outside the United States unable to return. Even if you have advance parole, which is a document that allows you to travel internationally while your adjustment of status is pending, you should think very carefully before using it. The immigration landscape is changing rapidly, and what is allowed today may not be allowed tomorrow. The safest approach is to remain in the United States until your green card is approved. What should employers do now? U.S. employers relying on overseas hiring have been significantly impacted by this announcement and need to take immediate action. First, Identify all employees or candidates from potentially affected countries. Review your pending immigrant visa cases and determine which ones are subject to the pause. Second, suspend start date planning tied to immigrant visa issuance. If you are expecting a new employee to arrive after receiving their immigrant visa, you need to adjust those expectations and communicate with the employee about the uncertainty. Third, explore non-immigrant visa alternatives where available. Depending on the employee's qualifications and your business needs, there may be temporary visa categories such as H-1B, L-1, or O-1 that could allow the employee to begin working while immigrant visa processing is paused. These alternatives have their own requirements and limitations, but they may be worth exploring. Fourth, document business impact in case future policy changes permit exceptions or relief. Keep records of the positions you are unable to fill, the projects that are delayed, and the economic impact on your business. This information could be valuable if there are future legal challenges or if the administration creates exception processes for employers facing significant hardship. Fifth, consult with immigration counsel. The situation is complex and changing rapidly. An experienced immigration attorney can help you navigate the options and develop a strategy that protects both your business interests and your employees. Now let me address the legal challenges that are likely coming. Immigration advocacy groups have already announced their intention to challenge this pause in court. The legal arguments will likely focus on several issues. First, whether the administration has the authority to impose such a broad pause without going through the formal rulemaking process. Second, whether the pause violates due process rights of applicants who have been waiting in line for years. Third, whether the country selection is based on legitimate public charge concerns or is instead a form of national origin discrimination. Previous travel bans and immigration restrictions have faced significant legal challenges with mixed results. Some have been upheld by courts, while others have been blocked or modified. The outcome of legal challenges to this pause is uncertain, but litigation typically takes months or years to resolve. Applicants should not count on courts to provide quick relief. What comes next? The State Department has not indicated how long the halt will last, only that it will remain in effect while officials reevaluate immigrant visa screening procedures. With lawsuits likely and a full country list still pending, further changes are anticipated in the coming weeks. There are several possible scenarios. The pause could be lifted relatively quickly after the State Department completes its review and implements new screening procedures. The pause could be extended indefinitely while the administration develops and implements its expanded public charge policies. The pause could be modified to affect fewer countries or to create exceptions for certain categories of applicants. Or the pause could be blocked or modified by court order in response to legal challenges. The uncertainty is one of the most difficult aspects of this situation. Applicants are unable to plan their lives because they do not know when or whether their cases will move forward. This uncertainty affects not just the applicants themselves, but their families, their employers, and everyone who depends on them. Now let me share with you the full list of 75 impacted countries. Please listen carefully to see if your country is included. Afghanistan, Albania, Algeria, Antigua and Barbuda, Armenia, Azerbaijan, Bahamas, Bangladesh, Barbados, Belarus, Belize, Bhutan, Bosnia, Brazil, Burma, Cambodia, Cameroon, Cape Verde, Colombia, Côte d'Ivoire, Cuba, Democratic Republic of the Congo, Dominica, Egypt, Eritrea, Ethiopia, Fiji, Gambia, Georgia, Ghana, Grenada, Guatemala, Guinea, Haiti, Iran, Iraq, Jamaica, Jordan, Kazakhstan, Kosovo, Kuwait, Kyrgyzstan, Laos, Lebanon, Liberia, Libya, Macedonia, Moldova, Mongolia, Montenegro, Morocco, Nepal, Nicaragua, Nigeria, Pakistan, Republic of the Congo, Russia, Rwanda, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Senegal, Sierra Leone, Somalia, South Sudan, Sudan, Syria, Tanzania, Thailand, Togo, Tunisia, Uganda, Uruguay, Uzbekistan, and Yemen. If your country is on this list, please take this information seriously and plan accordingly. This is not a time for panic, but it is a time for careful consideration of your options and proactive steps to protect your immigration future. Let me offer some final thoughts and practical advice. Immigration to the United States has never been easy, but the current environment is particularly challenging. The rules are changing rapidly, enforcement is becoming stricter, and the margin for error is shrinking. In this environment, information is your most valuable asset. Stay informed about policy changes by following reliable sources like U.S. Policy Brief. Do not rely on rumors or social media posts that may contain inaccurate information. Verify everything with official government sources or qualified immigration attorneys. If you have a pending case, be proactive about protecting it. Respond promptly to any requests for evidence. Keep your contact information current with the embassy or USCIS. Maintain copies of all your documentation. Consider consulting with an immigration attorney, especially if your situation is complex or if you are unsure about your options. The cost of professional advice is small compared to the potential cost of making a mistake that affects your immigration future. Finally, remember that immigration policy is ultimately shaped by political decisions. If you are a U.S. citizen or permanent resident who cares about these issues, make your voice heard. Contact your elected representatives and let them know how these policies affect you and your community. Make sure you subscribe to U.S. Policy Brief and hit that notification bell so you never miss an important immigration update. Share this video with anyone who might be affected by this processing halt. The more people who are informed, the better prepared we all are to handle whatever comes next. Drop a comment below and let me know how this news is affecting you or your family. Your stories matter, and together we can support each other through these challenging times. Thank you for watching U.S. Policy Brief. Stay informed, stay prepared, and remember that even in uncertain times, there is always hope and there are always options. I will continue to bring you the information you need to make the best decisions for your future. Until next time, take care and keep fighting for your American dream.